Hi, everybody. Thanks for joining us today on our will seminar, our second estate seminar webinar, I guess. Roadblocks to maintaining or completing a will. Just wanted to welcome all of you guys along, and we really are glad that you're able to make the time today to join us. And really thrilled that we actually have Matt Trotta, a lawyer that we've been using for many, many, many years now in our business, and good time to ask the lawyer the questions you've always wanted to know. So that's why we're doing this, is just to get you guys informed on completing your estate plan. And of course, doing your wills, power of attorney, and personal directives are one of the great parts of your estate plan. So welcome, Matt. Welcome, everybody. So of course, on the roadblocks that we often see as part of our practice, and kind of, why we decided to try to do this as a firm for a lot of our clients, is to look at, a lot of people think these are the people that need the will. And a lot of people say, you know what, I'm quite young and I don't need a will. I don't need to do any planning. And of course, it's like, I'm not that age that I need to do estate planning. So that's the biggest roadblock that we tend to hear at the Tower Group. Don and Marg have always been great clients of ours. They had been clients of ours for actually 20 years when Don passed away. He actually had been going to the doctor in Canmore for quite some time and been diagnosed with bronchitis. Kelly and I showed up to actually see them for a meeting around Christmas time and thought there's something wrong. And you could tell there was something wrong, and you could tell he was really not doing well. And Mark said, well, he just went back to the doctor yesterday. He has bronchitis. And you could tell the way he was breathing. You could tell the way that he was just behaving. And I said, you know what, Marg, I think we need to take Don back with us. I think you need to come, and I think we should take him to a Calgary hospital. So that happened, but in the meantime, they didn't have enough beds at Tom Baker, which they diagnosed him with cancer. We ended up having to take him back to the Canmore Hospital, admitting him there, to which he passed away 7 days later. But one of Matt's colleagues at the time, because Matt was away on Christmas, one of Matt's colleagues actually came and did their will at Christmas time because they had a friend that could do it, but their friend also passed away right before. So we were really thankful that that lawyer was able to come to the hospital, because as you can see, he passed away 7 days later. So we got the will done in the Canmore Hospital. Not the time to do a will. Then of course people say, well, I'm too young. Well, Naomi was not only a friend of mine, but she was also a client, and she was a tough client because, she was young and she was like, I don't need disability. I don't need critical illness. I'm good. I'm totally young. And her and I kind of fought over it a little bit. And she's like, oh, I know you're a big fan of all this stuff. And that's kind of how she phrased it to me. And she was like, okay, fine, I'll sign up for this stuff. And I guess it's what it is. She ended up getting into a really great consulting job with an oil and gas company, and was super thankful when she got diagnosed with terminal cancer that went fairly quickly. And of course, she's like a lot of other people, where she says, oh, I've got it done, and I'm getting all my estate plan in place, because she was actually too embarrassed as a type A to say that she hadn't done it. And especially to her friend that does these type of things also as a planner. She came into our office completely yellow, with completely yellow teeth and yellow mouth, and all of my staff were shocked. And for me, myself, I looked at her in the eyes, and she just looked at me and nodded. And I said, you didn't do your will, did you? And she goes, nope. And it was just one of those communications. Ended up calling Matt. Matt was in my office, and less than an hour later, and she passed away in less than a week after that. So again, not the time to be planning your estate, but even then she hadn't done some of the estate planning stuff or written down some of the things that I got her to do. So that's another big one that, again, you don't want to be doing that in your last week, because sometimes you don't have enough time and you don't feel well enough. This one's a really interesting one. Dawn, 52 years old, recently married, and then passed away pretty tragically. And of course, walking our dog 7 o'clock in the morning, going right before work. So these are just 3 of the people that we've had in the past year that have passed away. So, this shows you, people often ask why we can take on about, 10 to 12 new clients. We usually have 6 to 8 to 9 people pass away a year. And for a small brokerage, that tends to be a big number. So you look, and these are the times that, again, she just was busy all the time and recently married and just didn't have the time to do it. And Matt, of course, you know, she passed away without a will, and Matt looked after that estate. Do you have any comments, Matt, kind of around that?
Well, to that, I'll just make a general comment that will, lead into many more comments later in this presentation about not having a will means there's a loss of control. And that means that it's a lot more difficult to be able to get things done in a timely manner when there's no document directing. If there's no document directing, we're relying on court processes, and that delays things. It makes things a little bit difficult, and it makes things a bit emotionally challenging.
Perfect, thanks, Matt. So here's the big question that I want everybody to think about. What would happen if you're plucked from your life at this very moment? How would your business fare if you have one? How would you handle what you left behind? So, our job at the end of the day here is obviously to give everybody reassurance, to give everybody the objective that, you control, you do your wills, you do your estate plan with us, so that you know that everything's going to be all right. Your family knows that everything's going to be all right, and you control how you want everything to be controlled at the end of the day, because that's really why we're here, is to make a difference for you and your family. Obviously, like many of you saw in the last session, we don't make money off the lawyers doing this. We don't make money ourselves on giving you this information. We just really value giving you that information as part of our plan and part of our estate planning process. We do have a what matters most process that goes through a legacy estate planning process for everybody. So, we're excited to do that for everybody, and excited to actually keep bringing these things to you so that you can start to plan your own stuff in the back scenes, to have conversations with your spouses, your family, people that mean the most to you, charities, things like that.
Hi, everyone. It's Jeff from the Tower Group. It's time for a quick poll. So you're going to see it pop up on your screen. Just answer the question that fits best, and we'll share the results with the group. So far, just an update, we have 30% of the people voting. We got 50%. We have 60. Can I get a 70? Okay, we got 70. 80%. We just need a few more. Going once, going twice. Okay, we're at 89. Can we get to 90? Okay, all right, we're at 94. I'm closing the votes.
Excellent. So as we can kind of see there, the majority of people, so there's the three real ones that stand out to us. I don't have time, and this topic seems overwhelming. So that's why we're doing these sessions, is hopefully this won't seem so overwhelming to you once we actually go through this. We also want to make sure that people are able to ask questions as we go here, because if you ask questions and we're talking about certain topics, we're going to try to bring your questions into the presentation here. So if you want to type them up, and then afterwards of the presentation as well, we're going to actually unmute everybody. And if you want to raise your hand, so if you go under questions, there's a hand raise that you can do. If you want to raise your hand on it and you put it up on the questions, we will actually see that raised hand and we'll unmute you, and you could actually ask your question, because now's the time obviously to ask the lawyer while he's on here, as well as ask us, because of course we help the lawyers in doing a lot of this as a certified executor advisor. So we can also help you with a lot of those questions. So excited to have everybody there, but obviously your big one is time. Other one is obviously the not wanting to leave people out as executors, and that's another big one that we'll discuss today, of why you maybe not want a lot of executors. Matt's going to discuss that today too, so we're pretty excited about that. So Matt, can you kind of tell us some of the roadblocks that you see in estate planning?
So interestingly enough, a couple of these, the top ones kind of, found their way onto my list as well. But these are my top 5. These are the ones that I've encountered the most with people. Number 1 being it's seen as something you do when you're older, when you've been given a bad diagnosis or something that you have to do. And what I always tell people is that's 50% of the answer, but not 100%, because a good estate plan is for planned departures and unplanned departures. And an unplanned departure, as Pam noted in the stories earlier in the presentation, we can't predict those. And, you don't really want to predict them even if you could. But it's something that if you have real property, if you have a family, if you have, any sort of asset, and even if you don't, if you want to be able to provide some certainty, it's never too soon. And an estate plan goes far beyond a will. A will is just one part of the equation. You're definitely never too young to have an enduring power of attorney or personal directive, because as I tell clients, there are certainly worse things than death, and that would be incapacity, especially at a young age where it goes long term. So it's certainly not just for the old and sick. It's really for everybody who wants to be able to pass on a legacy or be able to take care of themselves in both planned and unplanned scenarios. My second one is very close to what was number 2 on the list, which is unsure, unwilling to commit to appointees. If somebody has 5 children, you don't need to have 5 executors, but maybe you do. In most cases, I would say there's no safety in numbers. Too many cooks in the kitchen create a bad broth. It's not a positive thing in most cases to have more than 1 or maybe 2 executors. One of the things to bear in mind with that is an executor doesn't really walk alone. They're always going to have the ability to take on advisors and to be able to work with the families. And so the idea of who you choose isn't necessarily, do I have to pick all of my kids? It may be, do I pick my kids at all? And part of this in unwilling or unsure to commit to appointees, I see a lot is with spouses who can't agree on who the guardian of the kids are. Well, rule number 1 on that is you don't have to have the same guardians. It's the last person to pass decides. The second thing on that is the older your kids have, the more of an influence they have. So it's important to, broach the subject depending on the age, depending on how direct you want to be. But essentially the question becomes, if something happened to mom and dad, who would you want to be with? Because pulling a junior high student out into another province or another country is going to be detrimental, and it's going to cause problems. And that's something you have to think about, not just, well, I have to appoint my mom or I have to appoint my sister. It's and I have to appoint my spouse's family. It requires introspection, but it's certainly something that requires conversation, and it's shouldn't be a roadblock. It's a conversation piece. The third one is the perceived cost value proposition. This happens quite a bit where people hear that, in the 1980s, their dad got a will for $75, or Staples has a will kit that they claim on the form is 100% valid. Well, that can be a bit of a roadblock to consider, but the important thing to realize is in that value proposition is if something happens and you don't plan for it, or you plan poorly, now you're asking somebody else to have to spend essentially your money, or the money that you wanted to have pass on to the next generation to fix your issues. And so in almost every case I've ever encountered, planning in advance is cheaper than fixing a mess later. The fourth one is, that intimidation or stress, or as number 1 is overwhelming, of the idea of considering your mortality, considering your incapacity. And they're certainly not easy topics to have. And as estate lawyers, you try to keep it as light as you can while not making light of the situation. But the thing to bear in mind with this one is as tough as it is to think about these things sometimes, you want to think about these things when you're in a good frame of mind, when you're healthy, when you have control of your life, because if these decisions are being made in the situations that Pam brought up, in a situation where you're motivated by time, you're motivated by an issue, are you going to be making the best decisions that you could be making? Or do you even have time to plan for everything? Or is the plan going to be, let's create something quick and versatile and hope to God that my family and friends can fix it later? Because a lot of times, when you're dealing with a deathbed will, you're going to miss things. I worked on a file a long time ago where we didn't find out until after the person died that they had children from another family, and they didn't want to tell their wife in front of her. So in the hospital, the lawyer's instructions that took that were kind of missing a key piece. And that's something that you may not have a situation as interesting as that, but it may be something else they may not know about, a company. You may not recall an interest in land that you hold. You may not recall the designations you have on a plan when you're doing it on the 11th hour. And so as intimidating and overwhelming as it seems when all is well, it magnifies when you've got a ticking clock going on.
Matt,
the fifth reason that we come, sorry?
I was just going to say, I know we have a question just in regards to the guardian. So to go back to that just quickly, if a guardian, let's say, is going to university and the kids are over 18 and they're 19 and 22, should you still appoint a guardian to kind of look after them while they're going to school?
Good question. Technically, they would be adults under the law, at least in Alberta, under the age, they'd be of the age of majority, and so they wouldn't have a legal guardian per se. However, there is, they are still considered a family member for the purposes of maintenance and support. So it becomes a bit of a blurry area, but no, at that point, a guardian wouldn't be valid. That being said, you may still want somebody to help take care of your kids. So it's certainly not outside the realm of possibility to work out some sort of arrangement. I haven't actually drafted anything like this before, but it's certainly possible to have a trust where if a child is over the age of 18 and under the age of 25 and they're cohabiting with family, that maybe funds can be made available for that. We draft trusts to be relatively broad to conceivably allow for that, but we could have specific provisions for that.
Perfect, thanks. And I thought too, maybe you could bring up, because I know we've had numerous incidences just with some estate planning that you've helped look after when someone's passed away, is a lot of times there's a lot of documents that people have had done up that banks and insurance companies can't accept because it was poorly written. Can you kind of talk about that a little bit?
Sure. So there's two issues with that. The first issue is banks and insurance companies may not follow the horribly drafted language, but the courts might. So you may create some very unstable outcomes, we'll call them, where nobody knows how it's going to go. I mean, even an estate litigator would tell their client that we're rolling the dice when we have uncertain documents. The other part of that is there's a cost to enforceability when you have that sort of issue where you have something that a bank should be recognizing, or land titles should be recognizing, or an insurance company should be recognizing. Well, how do we get around that? Well, it might be a court order. It might be having to work with the bank to find a different solution. It may be commencing action against the insurance company. But the key in all those things is expense. And so it's undue stress on the family during that time. I mean, they're saying goodbye to a loved one, or they're learning the new normal of having a permanently incapacitated family member and finding that their power of attorney doesn't work. So not only do we have an added cost when paying a specialist to do it right would have been cheaper, we also have this added emotional stress.
Yeah, and we have another good question in regards to some of that too, because one of our clients had asked here, should they feel compelled to actually ask one of the family members to be an executor, or should they ask someone more financially savvy are better with financial matters, and he kind of asked us if we can help solve that. So I can discuss the first part of it, just saying that, you know, there hasn't been a client that we have, and that's part of the fees and everything that we do for clients, obviously. And same thing with this What Matters Most program and legacy program that we work with. We work directly with Matt always to solve all of our clients' estates. We have never had an issue ever solving any of our clients' estates. And because Kelly and I are both what's called a certified executor advisor, just like Matt was discussing earlier, we can actually help the executors actually go through the estate. So I wouldn't say you want to be compelled to have that family member, but you definitely, you know, what I've seen is there's sometimes people are named someone that knows nothing about financial and they have no clue. They can certainly use us, but sometimes it's a hindrance if they don't understand anything, or someone names a child that's just recently 18 and that's just overwhelming for them. So that's something that, you know, from my perspective, you want to look at. And definitely, you know, Kelly and I help with the certified executor. We help the executor do everything, like even for Marg and Dawn and Naomi's husband, you know, we sat in the boardroom and Jeff actually even changes bills for them. And we talk to the bank. We have the bank sit down in our boardroom for anything that they do. We don't run all over the city like many executors try to put it all together for years and years. It doesn't happen that way with us. We do it fairly quickly. It's not emotional. We work super close with Matt, and Matt, you'll have some comments to that too.
Yeah, and I think I'll get into a lot more detail a little bit later in the presentation about choosing executors and where that can go real south and where that can go real well. But I think Pam kind of nailed it, where you don't necessarily walk alone as an executor, and I think that's really important. But I would say if you feel compelled to appoint someone, they may not be the best decision. It should be somebody that you are sure would do a good job, and that, you know, if you know, you have family members and friends that, you know, you love to death, but, you know, they find a way to ruin a good thing, or they have problems of their own, or your family doesn't get along with them, or they don't respect your family. I've dealt with a couple of estates where we have siblings of the deceased who really don't respect their deceased siblings' kids. And I say kids, we're talking about people in their 30s and 40s, and just make an absolute mess of an estate. But that's who they were compelled. They were duty bound to appoint their siblings. And so there's no one size fits all answer, but I think you got to look beyond, you know, are they family to, are they a good choice? And we'll go over some of the things to be thinking about with that a little later on. So just to kind of wrap up this fifth roadblock, it's an interesting one, and I'll, you know, I have to deal with it carefully, but people don't like wills sometimes because they're putting things out on the table. They have to say what they own, or who they want to benefit or who they don't want to benefit. And that can sometimes be a bit daunting, but at the same time, it's all going to come out in the woodwork. When it comes to privacy, there are ways beyond drafting a will that we can deal with succession. We can put up trusts, we can create holding corporations, joint ventures, we can do bare trusts. There's a lot of different things that we can do depending on the situation, depending on the property. I know with some cultures it's bad luck to consider contemplation of death, and that's a tough one, and we certainly empathize with that, but it's something that it's coming for us all at some point. And there's often solace in knowing that if something happens, you've got, you know, things in place. One that I've dealt with a few times is a belief that it's handled by a family patriarch. It's handled by the traditions of a faith. And I worked on an estate where we had to rip apart a religiously drafted will because the daughters were treated as half of sons, and they were in need of medical assistance and in need of support. And, you know, that becomes a roadblock both on the planning and the administration. But I think, you know, bearing these things in mind, roadblocks are simply that. They're roadblocks, they're not barriers. They're things that, as a professional, as a team, you know, we can't solve it for you, but we can help you solve it. We can help you ask those introspective questions to get beyond these roadblocks and move these things forward. And I think this is a good way to segue into executor appointments and some of the issues with that. So what are the problems with executors? It's often the extremes. They're either too young or they're too old. If you've got an 18-year-old son or daughter or nephew or niece, and they may be an absolute savant with life, should they be an executor? Probably not. I worked on an estate with a 21-year-old executrix, and she was fantastic. She was one in 1,000. You won't encounter many people like her that were so grounded and so deep in reality. But at the same time, you know, we were so involved in that estate. There may have been a question of who was really the executor of the estate. That's a bit of a problem. And in most cases, you're not going to find somebody when the chips are down, when they've lost both their parents, that can handle that sort of situation. Conversely, if you are looking at your estate planning, and you're planning to live to a ripe old age of 106, you know, your brother or your friend who's a couple years younger than you, you know, they may live to 106 too, but they may not be in very good condition, or they may not want to be able to do it anymore. I mean, unfortunately, I've seen dementia take brilliant minds very young, relatively speaking, and so that's something we have to think about a little bit as well. And a lot of times when we're dealing with kids or grandkids or nieces or nephews, we're setting up trusts to last a period of time, or even when we're not dealing with young people, if we're dealing with somebody with a substance abuse issue, or we're dealing with somebody with a permanent or indefinite disability, you know, we want to be able to make sure that in most cases, the executor is also the trustee arising from those trusts, and that person can see it through, or we put up a framework where the people that you would want to see them through can see them through. And when you're dealing with, you know, a do-it-yourself filling out a form, or you're dealing with a lawyer who agreed to do it for $500 because they're also doing real estate deals and divorces and provincial court applications, they may not take the time to kind of critique your appointees. And that's where you can see these extremes pop up a lot. I just did an estate for the will from 1980 where the executor appointees had been dead for over a decade. But again, you know, that's something to consider. And then we get into the third point.
Before you go into that, I think, you know, like that's something that we even tried to hammer home in the first webinar. Because I think in my experience, I've seen so many, like I always rank them in some senses, which is really absolutely horrible from a professional standpoint. But, you know, when you look at the wills that we have seen, like it's almost, you know, some of the best divorce lawyers across Canada are some of the worst estate planners. So we often say, please don't offer our clients any kind of wills, because it's like, you just don't want that done by somebody who is a divorce lawyer, because they just don't know some of the tax laws. They don't know some of the estate laws. They're not taking the time to sit and really discuss the estate matters, which there's a lot of estate matters in a will. And I think that's what, you know, we've always sat down with our clients and tried to go through all the details and trying to go through all of that. And sometimes people are just in the middle of divorce and they're like, oh, they just did it up for us. And it's like, oh, it's horrible. And it's like, is this really what you want? And they're like, well, no, not really, but they did it anyway. And it was like, don't get caught in that kind of situation where that happens. Because of course you want somebody who's actually experienced in estates.
Exactly. And even a good precedent in the wrong hands can be incredibly dangerous and create an incredibly bad product. You know, moving on with the executor issues, kind of back to that question, you have people being picked with insufficient experience, knowledge, and temperament is a really important one. Kind of going to that example of, you know, the uncle and aunt who have an issue with their niece and nephews. Or you have somebody who, you know, is really good with everybody, you know, they're the family peacemaker. Well, are they going to be the right person for the job to deal with a private corporation where there's two other shareholders who aren't family members? Or are they going to be able to deal with the fact that you passed away halfway through a divorce? So there's you know, things that have to be borne in consideration, and that kind of goes back to what Tom Deans was saying on Tuesday, where you know, you can't just say, okay, every 5-10 years we're going to look at it. I mean, lawyers, we put 5 years out there, just like dentists put every 6 months. It's a good number to remind people, but you really got to take ownership of it yourselves, to take a look at it, to read it, because you don't want to necessarily pay a lawyer to look at it every 6 months with you to say everything looks good, but you are the best judge of these things. And the biggest issue often will come from executor appointments, because that's the person who is piloting this through. And if you have an incompetent pilot, it doesn't matter how good the instructions are. So from there, the next issue tends to
really great question on executors again is someone saying, you know, my colleague actually named an executor, and he was telling me that he named this executor because it's such an honor for him to be an executor on the estate. And when I asked him the details of, do you know what that executor does? And he said, no, not really. So he's asking, how big is that job as an executor?
Well, it's not an honor, it's the scarlet letter in a lot of ways. Being an executor is a long-term commitment. You're looking at a minimum of 12 months, realistically more like 18 months worth of work. If it's a straightforward estate, it's still a lot of heavy hours, but you know, the trust companies like to talk about how there's about 100 different tasks in estate administration. And in a way that's true. But in another way, what you are as an executor is you are essentially a manager, an administrator, and a delegator. And you have to be able to know when to do each. And that can be a bit of a challenge. So it's not an honor to bestow on a friend, on a family member, sometimes even on a spouse. That can be one of the worst things you can do to somebody. And sometimes, you know, you may want to appoint a professional, or you may want to just appoint a friend and make it very clear that this person should hire a trust company, hire investment professionals, hire a lawyer, hire an accountant, and not just to apply for the grant of probate, but maybe to be an advisor as well. And I think, you know, as Pam and Kelly are certified executor advisors, that's part of that role. It's also important, you know, as an executor, you're also boots on the ground. In some cases, you're going through basements and looking through old records, and you know, maybe there's some diamonds in the rough, and so you have to be a little bit wise to some of these things. And that's why it's important that they're not too far from the jurisdiction if that can be helped. If you're outside of Alberta, even if you're from Lloydminster, Saskatchewan, you're a foreign personal representative under Alberta law. And that means you have to either post a bond for the value of the estate less any amount the court says you don't need to, or obtain a dispensation from that requirement. And that typically involves getting the approval of all the beneficiaries. So if we think we're going to have difficult beneficiaries, that's the first place they're going to cause problems. So if you have somebody in Alberta, even if it's a co-executor where you have one in Alberta and one in England, you know, you're okay on that point of view, but it's something to always be mindful of. One that pops up an awful lot is having an executor in a conflict of interest or a potential conflict of interest. So this may be the second spouse may be in a conflict of interest with the kids of the first marriage. This may be a brother or a sister who is also a director and shareholder of your private corporation. It's important to be really mindful of these potential conflicts. Everybody may be sailing in the same direction now, but what happens if, you know, situations emerge where money becomes an issue, where corporate governance becomes an issue, where there's a brewing disagreement between a beneficiary of your estate and that sibling or that friend. So it's important to be mindful of that, and a lot of times that creates some added chaos. Like we mentioned earlier in the presentation, too many cooks in the kitchen makes a bad broth. So too many executors can be a real problem, especially when you have to get everybody signing off. Even applying for a straightforward grant of probate, it can be herding cats to get 4 people to sign the application at the same time and make sure they all reviewed it, make sure they all understood, and make sure they all had their input. And that's just the easy part, because we're aggregating all this information. Now what happens if you know, we are dealing with bigger issues. If there's a fight within the executors, how do we sort that out? So it's important to bear in mind that there's no safety in numbers on this. Sometimes it makes sense on certain estates to have 2 or 3 executors, but in most cases it doesn't.
And it costs a lot more money, Matt, doesn't it, to once the siblings start fighting and the lawyers have to get involved. That's a lot more money in the estate to start spending to fight with the lawyers in place too.
Well, imagine if each one has their own counsel, or even if the estate has counsel and the beneficiaries have counsel, and maybe there's a counsel for a spouse, and they're all going to try to seek against the estate. Are they going to get it? Probably not, depending on the circumstances, but maybe may settle in for some of that. But when it comes to litigation, unlike a lot of our work, there's not a whole lot that gets delegated down to paralegals at a fraction of the rate. You're paying lawyer rate, and if it's a big rate issue, you're paying somebody $500, $600, $700, $1,200 an hour for their time, depending on the stakes. So that's something to kind of bear in mind on that. The other one I see a lot is when somebody does a homemade or do-it-yourself, or the real estate lawyer who's my buddy drafts the will, they don't appoint an alternate executor. So what happens if your appointee's gone? Well, now it's what we call a grant of administration with will annexed, and we go to the statute and we figure out who's entitled to apply. And typically that would be a beneficiary, depending on the type, how the will's drafted, if it's a specific or a residual. But effectively we lose control. It goes to the statute, and everybody who fits into that class has an equal right to apply. And if, let's say, we land where there's 3 or 4 kids are all of the same class, 2 of them don't like each other, now we've got a problem and we've lost control of the situation where we're governed by statute. The last one that I've seen a lot is not talking to people before you appoint them. When I worked for the trust company, we had that a couple times. We get a phone call and they say, hey, I'm the executor of an estate and I don't want to touch this. What do I do? And so for a trust company, it's great. They lick their lips and go, here's our fee agreement, appoint us. Which could be good, but again, it's a loss of control. You thought you handed the keys to somebody, and now because you didn't make sure it's something they're actually willing and able and competent to do, they're handing it off to somebody else, or they're walking away and now we're going through the statute and trying to figure out where we go. So it's important to bear that in mind. And what can be worse than that is if we have a will that is unclear on how we appoint those, or it purports to create a way to appoint executors or to govern executors. And that's why sometimes it's even better to just rely on that statute, even though we're losing control, because at least there's some certainty. And, you know, we can kind of go from there to discuss whether or not it's worthwhile having a will at all, if it's going to be a poor one.
Great, thanks, Matt. We're going to do one more poll. So everyone, you'll see a poll launch up on your screen. Please select your answers and we'll share the results with the group.
Oh, well, are people sleeping? Oh, now we got some people doing it. Good time to wake you all up, I guess.
Right now we're at 58%. Oh, just jumped to 68. Oh, just jumped to 79.
There we go.
Now we're at 84. Can we get to 90? Okay, going once, going twice.
So as you guys can see, pretty much, Jeff will show the poll here. So really the majority of people, their will is 8 or more years old and has personal power of attorney or personal directive. And then the next one is they don't have any documents and have questions, and they have a recent will and nothing else. So that's good if you have a recent will, but if you don't have a personal directive and power of attorney, as you're kind of seeing with this COVID thing and the seniors homes especially, you really need a personal directive in place, because of course now you don't have that person looking after you anymore. And you know, the doctors are now having to make decisions where if you don't have extraneous measures you want to take, they're not taking you out of that home. They're saying, you know, hopefully you can get better, and if you can't, then this is where you stay. And it's the people who have the personal directives that Alberta Healthcare is being directed to take out of the homes to the hospitals and doing the special measures. So at least that's what's happened here in Calgary in the south and Mackenzie Town. You know, they've really tried to explain that to the families, and I think that's a really big one. But Matt, maybe you'd like to discuss too the danger of something that's getting to be 8 or 9 years old or 10 years old.
Sure. So one of the things that happens a lot of times is even if your life doesn't change, the laws often change. So the Income Tax Act, without any exaggeration, has changed at least 9 times in the last 8 years. So what does that do? You may have a situation where you had a really slick plan with testamentary trust planning, and now you're just making CRA really happy because that trust is inefficient. The Act has changed. The Administration of Estates Act is now the Estates Administration Act. The Wills Act is the Wills and Succession Act. Even just in January, the Matrimonial Property Act has been changed to the Family Property Act, and it changes how we deal with adult interdependent partners and their entitlements to property, which affects your plan. So even if your life hasn't changed, the world around it has changed. And, you know, wills often rely on the statutes in force at the time, as they should. And so over time, those things change and the plans may not be as effective as they used to. And so with that, we'll kind of talk about the common features of what I've seen as what I consider poor wills. They're not often properly executed, which is in the presence of 2 disinterested witnesses, unless it's a holograph will, which is completely in your own handwriting, not something printed off the web that you signed yourself. What happens a lot of times with these? Well, a lot of families think they can say, well, it wasn't a real will, so we don't get it validated. Well, you don't have to, but somebody might want to, and that's going to be a problem, and that could become contentious, and it's going to be expensive. Any trip to the courthouse, you're measuring in thousands. I'd say at minimum 3 to 5, and that's if it's not opposed and we don't have to do affidavit evidence. Same thing with when it's signed without oversight. If you know somebody doesn't really take the time to get to know the clients, get to know the situation, you know, they may not learn about the nephew that owes them a lot of money, who's all of a sudden, you know, a beneficiary, or they may not realize that during the course of a half an hour discussion, the spatial awareness of the client is dissipated. And I sat down with a client one time where we were talking about dollars, and all of a sudden she was, you know, it went from thousands to billions, and knowing people for months was years and decades, and the numbers and awareness has completely disappeared. But if I only had spent 15 minutes with her, I would have thought she had her capacity. And it wasn't until the end of that conversation where you realized it faded real fast in the course of a conversation, because when people do have degenerative issues, neurological issues, they can often show well for a very short period of time. Either because they've coached themselves or somebody has coached them to remember certain things or to say certain things. But if a document isn't speaking to what a person's testamentary intention is, it may not be valid, and that could be a real problem. And again, it's a trip to the courthouse. I've already talked about the executor issue. One of the things you see a lot in basic ones is not accounting for debts, taxes, creditors, the ability to pay for those. Especially if you have assets in another jurisdiction, it may not discuss how is that paid out? Is it paid out of Canadian assets? Is it paid out of the proceeds of that property? What are the options? Can we elect in certain ways under the Tax Act? Can we donate to charity? And a lot of times in a basic will, they won't have any discussion on whether or not they can do that. And without donative intent, there becomes a question of, can we use these charitable tax credits on last year to reduce capital gains? How are they treated? Again, assets outside the jurisdiction can become a real problem. Every state and every province has their own quirk on things. So for example, in a state like Florida, an executor has to be a blood relative or a resident of the state. So if we know we have Florida property and we're appointing somebody's buddy, or we're appointing even a trust company, that can be a problem because not every trust company can operate in every jurisdiction. I mean, in Canada, that's not a problem, but if it's in the United States or it's in Central America, then it may become a problem. So these are questions that need to be asked. The size of the estate often can be exaggerated or understated. This is especially an issue when people gift a lot of their estate in cash amounts. So they'll say, to my brother 500,000, to my sister $1 million, and then to my kids the residue of my estate. Well, that can create some very interesting outcomes if you think your estate is worth 10 million or 2 million. And I worked on an estate litigation file that lasted for several years where that's exactly what happened. Dad thought he was worth about $25 million, and then 2008 hit. And he made some decisions that weren't so good. He had a couple of divorces. All of a sudden, 20 became 6. And that made a huge difference on what everybody got. And that can be a real problem. Should that will have given out so much in specific gifts? Definitely not. Lack of flexibility and clarity is a huge issue in a lot of wills where we plan for today, but we expect rules to change. We expect your situation to change. We often will say that when we're trying to figure out values of assets, it's horseshoes and hand grenades, because by the time you leave our office, the stock values have changed. Everything changes constantly. But if we don't have the ability to address that, it becomes a real problem later. That lack of detail, that lack of focus in understanding particular situations is a big problem, especially when you're dealing with service offerings that try to fit it into a design mold where you get half an hour with the lawyer, you get a drafted by a paralegal, you sign with them so they can manage to do that at rock bottom prices. Do they understand the situation? I've had 3 files in the last year of a will, EPA, and PD that were drafted by another firm in the last 12 months that had to be completely rewritten, because had these people died during that time, we would have had issues with distribution that would have cost the estates hundreds of thousands of dollars, because we were dealing with estates with trusts and private corporations, and people didn't realize what they owned and what is owned by an entity controlled by them is different, and the lawyer didn't take the time to teach them that, and it would have been a real problem. One of my favorite situations that I've seen is what I call ruling from beyond the grave, where somebody will have a trust drafted up, or they'll do it themselves, that is so onerous and so burdensome on a beneficiary or on the executor or trustee that it's going to be problematic. And what's going to happen is somebody like me is going to try to figure out how to jailbreak that trust to get the money out, or to amend its terms, or to do something to try to make sure that it's in the best interest of the executor or the beneficiary, depending on who I'm representing. But it becomes a real problem, because at this point, it's not smooth administration of the estate. It's not going to be the trust making money to give to the intended beneficiaries. It's the trust digging money to pay for outside counsel to fix a problem. And that's going to cost way more in the future, because we're not paying present value lawyer a little bit more. It's time value of this lawyer 10 years down the road, and at lawyer rates, not paralegal rates, not, we're not going to be able to deal with anything in form. It's that lawyer working on it at their rates for as many hours as it takes to solve the problem. We have issues a lot of times where the gifts aren't properly stated. What happens if a gift fails? What happens if a beneficiary doesn't make it to their age of entitlement? What happens if little Johnny doesn't go to university? And what is a university? The state count. Situations like that can cause a lot of problems. One of my emerging favorites is insurance designations or registered assets like TFSAs and RSPs, where the will speaks to them in such a way that completely screws up the estate plan, creates tax liability, creates family acrimony. Because what people don't realize is insurance companies may not need to recognize that there was a change of designation if it was done poorly in a document, whether it's compliant or not. But the courts may recognize it, and it could create some very unknown and damaging outcomes. It could create tax liability where one wasn't there before. And this can happen when people don't realize it. They have a will and they go, oh, I just need to change this one thing. They change their designation in a one-page codicil without thinking about it. Creates a lot of problems.
And I know, Matt, like we've ran into a few problems, and I know Millie, you're on this session and had asked this question too. So I wanted to recognize that. You know, I don't think a lot of people necessarily realize is that RSPs can roll tax-free to a spouse, because a lot of people are shocked that when somebody dies and it's like, well, I wanted to leave my RSPs to my kids. And if you do that, your RSPs actually are taxed on your death, and same with RIFs and same with pensions. So that's something like Matt was just talking about, where really from a tax perspective, that's a big thing. And some people too, even with us, have named other people in their insurance, but then put in their will someone else. And so, of course, that's something that the insurance company then has to battle out with part of the law. And we usually have to involve Matt or involve other lawyers if the will's written up with someone else to try to get that organized. And sometimes the insurance companies will go, well, what we have on file is what stands. And unless you're going to take it to court, they will try to stand on it with their lawyers. And we've seen that even with RSP designations, is that, you know, it contradicts what you're saying. So you always want to make sure that you're updating it. And some people think just because they filled out a Form 2 at the bank with their RSPs that it's changed. And I know even for myself, I've had to submit like 3 before on one of our clients to even see it on file. So it's like, and I've gone there myself with people that we know, and it still hasn't gotten changed by the bank's head office. So it's, you know, there's some reality around that, I think. And, you know, Matt, you could kind of talk a little bit to that too.
Mm-hmm. No, absolutely. And, you know, you get these, it creates uncertainty. I had a file where we drafted a will, we had our designation, we thought it matched up with what was in place. 20 days before the person died, they went and changed it and didn't tell us. So it got taken outside the estate. So the tax bill went to the estate, because that's something people don't realize, is if they gift their RSP or their RIF outside of the estate, the tax bill still goes to the estate, even though the end beneficiary is joint and severally liable for that tax bill. So it just creates a complete headache. That designated beneficiary died under 30 days after the death of the deceased. So then we had the situation of who had money to pay for this tax bill, because that was the primary asset of the estate and the primary asset of the sister's estate. So several years and several $1,000s later of paying tax counsel, we were able to resolve that problem. But that problem shouldn't have existed. Had the designation not changed, the money to pay the tax, the intended beneficiary, the intended gift over beneficiary was all in that original will. And just kind of to wrap up some of the common features of a poor will, it's that copy paste, poorly drafted, outdated, and those tend to cause a lot of problems because a lot of times things change. And when you have that issue, when you have a poor will, it means you're going to have a poor estate administration, and it's going to have a lot of acrimony and a lot of challenge, even if it's not going to litigation.
Thanks, Matt. We also have a question from Bill. He's asking, can it be a conflict of interest if you are executor and are a beneficiary? Is that a problem?
In most cases, no, because you have a duty to yourself as a beneficiary, and you have a duty to act in the best interest of all the beneficiaries. It's not uncommon to be in that relationship. Often what we'll build into certain wills where there's certain things at play is a conflicts clause, where if it pertains to that person's interest, where they're exercising their discretion in such a way that it may disadvantage another beneficiary of that class, then that executor may not get to make that decision, or they may have to have it approved by all the adult beneficiaries. So there are ways around that, but on its face, no, it's not an outright conflict, but if it becomes one, there are ways to address it.
Great, thanks, Matt.
And just a reminder for everybody, because I know there's a concern that someone might not be able to see the question box. The question box will be on the right-hand side of your screen. and you'll be able to see, you can actually like unlock the pane and ask the question, or you can send privately or send to all, and it shows up in that pane. So again, just go to that question box on the side, or at the end, again, just put up your hand on it as well. And that will show you, as you see under attendees, there's a hand, and you can put up a hand to show that you want to ask a question.
Okay, perfect. So these are the 5 sources of acrimony. This is what causes issues in an estate. And it all really boils down to failure to plan. That is the biggest one, because if we haven't notified appointees, if we don't have a family prepared to manage wealth, if you have a situation where people never realized mom and dad were worth $20 million and they don't know the first thing about it, mom and dad didn't leave much of a will, now we don't have the ability to train the next generation. And you get into what Tom Deans was talking about on Tuesday, where, you know, one generation makes it, one sustains it, one loses it. If you don't have the family prepared, you may see one generation makes it and one generation loses it, and then it's gone. And all that hard work and all the effort and all that is gone because they didn't know how to manage wealth, and they got caught off guard, and they weren't qualified to do it. They didn't realize they could ask for help. Or they're unaware of potential issues. I mentioned, you know, about the file with the unknown child. It may be not realizing that mom and dad owned business, or not being able to deal with an issue with that business, or an issue with what triggered, you know, death. I mean, we had that file with motor vehicle accident, and that happens, you know, an awful lot. And that's something to kind of to consider. Or my absolute favorite is planning on everybody getting along. And it's, you know, it's sort of like the idea of buying fire insurance. You don't want your house to burn down, but you have to expect that it could, because if you get caught where it did, and you didn't have insurance, you're in big trouble. It's the same thing if you assume people may not get along, or that things may ruffle people the wrong way, and they don't, then you're ahead of the game. But if you assume they're going to get along and they don't, and you don't have any plans for that, you don't have the right sort of language, the right kind of appointee, the ability for an executor to solve disputes, we're going to have a problem. And when we have a problem, if it's, you know, at very least, you may have 2 lawyers sitting on each side of the table with one group of beneficiaries or executors. And if we're lucky, that's as far as it goes. But if it goes into litigation, we're going into the tens of thousands of dollars. I think we've beaten to death how a poor will or an ambiguous will can cause a problem. That clearly passes on. The poor executor, we've dealt with that too. Not addressing personal and corporate issues. So this is important because a lot of things can't be handled in a will. This is where unanimous shareholders agreement is very important, because a will only be able to deal with what you own, what you control. So you own your shares, you move your shares over to the next generation or to the intended beneficiary. But what happens if you don't want that person running that business, or your sibling is who you're in business with and you don't want to be, and they pass away and you don't want to work with their wife and kids, or they can't, they don't know how, or it's a business that requires cash injection now and then. How do we deal with that? Well, the will can't say, I direct you to buy this person out. I mean, it sounds nice, put it in there, doesn't mean anything's going to happen. But having other things out there, unanimous shareholders agreement, having a family trust for certain things, alter ego and joint spousal trusts, which are self-benefit trusts that run during your life and upon death trigger a tax event just like death, but operate outside of an estate. Things like that may properly address these situations. So it's more than just a will, and not necessarily having that can be a source of real problem, especially if you have a situation where there's a business involved. And then, of course, failing to use professionals. I try to, in my precedents, beat people over the head with the idea they can hire experts, the estate can pay for them, it's important, it's okay. You know, sometimes it's worth getting a valuator to evaluate the price of a house, or to evaluate jewelry before it's liquidated, because you don't want that beneficiary coming out of the woodwork saying, you made a mistake, we could have gotten way more money and you're negligent. Well, that couple $1,000s for the valuator would go a long way to prevent that sort of thing from happening. So my favorite are people saying, well, my brother is, an accountant in-house at X corporation. They can do the estate returns, or they can file these things, and they know what they're doing. Maybe they paid really close attention and they did in-depth tax and they understand these things, but a lot of times they don't. And if you really want to postpone the distribution of an estate, run into tax issues, because you don't measure those in days or weeks. We tend to measure those in months. So from there, I think we'll open it up to any additional questions.
Perfect. We have a couple. So, and again, kind of talking to some of the stuff you were just talking about, like I think, I brought it up in the last session, but I think one of our worst estates was a family that, they did their picture on the stairs every year, and you met all the kids every time we were over at the house, and the kids all loved each other, and it was like one big happy family until mom and dad died, and there was money in the background, and the kids duked it out as hard as they could possibly duke it out. They each got one of the best lawyers in the city, kind of thing, to try to fight against each other. And 5-6 years later, they were still in estate issues, fighting litigation. Right now, that's still in the case, actually almost 9-10 years later, and the legal bills are almost $150,000 a piece. So, and I don't know how many conversations that Kelly and I had with that family saying, they're like, oh, our kids are so great. They're not going to fight. It's never going to happen. Look at these pictures. And they'd show you the pictures on the wall, meet my kids, and it's never going to happen. We have the closest family ever. And they all hate each other now, and they don't talk to each other now. And they fought over the Glencoe golf membership and this and that and cars, and it's stuff, and that's what was really disappointing to us, is that it's stuff, and all the stuff is actually going to go pay the lawyers. And
oh yeah, and once there's one problem, everything becomes a problem.
Yes. And so oftentimes people ask us, how much does it cost to do a will? And that's where it comes into pay somebody to do a proper will. And I think, Matt, you can comment to that, but I think on average, a lot of our wills have started at about $1,500-$1,600 and gone from there, depending on the complexity that people have, and whether or not you got business stuff and everything else on top of that, and trusts and everything else on top of that. But I think your average individual will is, $1,500 to $2,000 pretty easily.
Yeah, I think when we package it with an enduring power of attorney and personal directive, it tends to be about $2,000 all in for a spouse with mirrored, and that's where about we'd start. And that, is a fair amount of being able to have one-on-one time and phone calls and review and whatnot. Where do they range? For high net worth bespoke planning, I think the most expensive will EPA PD I've ever drafted was about $5,000. It was about 30 pages, had multiple trusts, and it was pretty convoluted. But at the same time, the cheapest application I've ever done for advice and direction to a court on a deficient will was $8,000. And that was just to get permission to interpret it a certain way. The one that I talked about with the religious will was over $10,000, and the public trustee had to appear, so we needed materials with them. So that's the cost of having to fix something later. Where my fees are, I've worked with 3 different firms and a trust company, so that's about in line with the higher end. You may be able to find a little bit cheaper here and there, but for people who are trained in tax, trained in estates, have that experience, have litigation groups and to support them, and corporate groups to support them, you're looking at starting at 2 and going up from there, depending on how much bespoke planning, how much tax is involved, family issues, are there ancillary documents? I mean, if we're doing USAs and trust deeds and other things, it's going to add up. But and a lot of times it's going to be, what's the value proposition versus what's the cost? So what can we save you? What can we prevent you from? That's really the key. And if we can't explain that to you, then question our fees.
And I think another question, comes down to, where do they start? And, is their will going to be enough? And, you know, they've labeled a brother, let's say, that's going to look after mom and dad and going to look after the other spouses. I would just really caution on the fact of, if you think that's really going to happen. We also did have an estate that named one person that was supposed to give everything else to everybody else, and they said, hell no, I'm not doing that. You have no idea what I've been through with all this stuff. It's not happening. And they were named as the sole beneficiary, and they didn't share with anyone else. And so, you know, I think that's a big thing. We often give people a questionnaire and start saying, you know, have the conversation in the background with your family. And I think that's the big thing, is going through, you know, figuring out who your family are, what all your assets are. Because I know a lot of times people come back to us and they're like, well, you know what my assets are, you do that. But I don't always know how much is in your bank account, or how much is, you know, stashed away in your safety deposit box. Because we've come across estates afterwards that, you know, people have actually stashed gold bars and stashed coins and stashed, you know, $10,000, $15,000 cash in a safety deposit box, and isn't even written into anything, that you didn't even know it was there as part of the planning process. So we try to gather all that information. Matt's got a fantastic questionnaire that kind of says, where are all these assets? And we're more than happy to sit down with people. We usually give you the questionnaire right off the bat and say, you know, fill in the stuff that we don't know, and then come back to us, because we have the process with our What Matters Most legacy planning, that we actually sit down with people and kind of go through the whole legacy plan. Because again, a will, power of attorney, and personal directives are only a small piece of really what you do, because you have to make sure the beneficiaries match. You have to make sure, do we have enough insurance to pay the tax bill? You know, because a lot of people don't even take that into effect. It's like, what is paying the tax bill at the end of the day for the wishes that you guys want to do? And if that uses up all your assets, maybe then we need insurance for that. And, you know, you might have an RESP for a grandchild, and it's like, have you got that written into your will? Because of course it's not necessarily going to go to that grandchild if you don't, right? So then it's like all these little nuances that go along with the estate planning. Also, even, you know, with Marg and Dawn, a big thing that she had no idea is all of her credit cards were supplementary cards to her husband. So she had never established credit ever in her life. And so you saw how old she was. And when it came time that Dawn passed, all of a sudden, you know, she was great. She said, you know, make sure you tell all the clients that this happened. We actually had to get involved with the bank, because the bank came back and said, she has no credit. We can't shift the mortgage to her. And so that's an issue that a lot of people don't think about, is that their spouses are all on the credit cards. So make sure you build your own credit, and you do those type of things with all of that, because that becomes all part of the estate plan that Kelly and I work on. And then we involve Matt all the way along with some of this, have discussions. A lot of times Matt's been in our office numerous times with clients, because we're just hashing through details before we get it right. And that's, you really want to get those things right all the way along. So I think that's really how we start and how we progress through doing that right.
I think that's exactly it. And are we going to nail 100% estate plan? It's like what Tom Dean said. No, not really. But but the goal is to be able to get as much of the understanding of the situation right now to apply to the reasonably foreseeable future, and to have the flexibility to get it right when the time comes. And I think that's really important. I think it's also an important takeaway that, does every single person need a will, enduring power of attorney, personal directive? Yes. Do they need to have unanimous shareholders agreement, trust deeds, paired trust arrangements? Do they need to have holding companies and structures? No, absolutely not. But you will be the best judge of your individual structure and what works for you and what you have and what your family situation is. So if you know coming in, hey, my brother and sister might, harass my kids to get some money. They worked for my company or something like that. Okay, well, maybe we do need a unanimous shareholders agreement. Maybe we do need to put those shares in a trust, and maybe now's a good time to crystallize the assets in your corporation into preferred shares and play around with who holds the voting rights for tax reasons or for personal reasons. So it really involves the ability and the willingness to have an in-depth conversation. And I think that's really the key takeaway is if you're not able to have that conversation and to see the value in getting this right, it's very hard to get it right. You know, we're experienced and have seen quite a bit, but we haven't seen it all. And we can't, within an hour, as good as we are, as good as we think we are, I'll put it that way, you know, be able to completely 100% identify all of your problems, all of your solutions, what you need without having an active participant back. And I think that's really important. And being able to ask the honest question, you know, is my kid the right candidate? You know, are my children good kids? Yeah, probably they are. Are they going to be good kids when the chips are down? I mean, you look at the story that Pam had, and a lot of times with these people, in their hearts of hearts, they knew it to be true. And sometimes it's asking the tough questions where sometimes people assume, oh, I'm going to outlive my husband, or I'm going to outlive my kids. Okay, you know, hopefully, maybe it depends on the situation. Maybe it isn't good if you outlive your husband, but it can happen where somebody doesn't. I'll tell a story when I actually got fired from a file once because I was sitting with a client, and she was a professional and she should have been up for this conversation. She was a recent cancer survivor, and she said, well, I'm clearly going to outlive my mom. And I looked at her and said, but what if you don't? And she found that horribly macabre and fired me. It's one of the only times I've ever been fired from a file, but you know, it's an important question. I mean, the type of cancer she had, and didn't realize I did research on it, had a pretty high recurrence rate. So if we're doing this right, if we're planning properly, there is a chance mom would have outlived daughter. And you know, sometimes it requires having that conversation, and it's not the easiest thing to have, but you know, at the end of the day, you know, the concern shouldn't be, do I feel good having this conversation, or do I feel good at the end of the conversation knowing that the plan's in place?
I definitely agree. And I think, you know, we want to be respectful of everybody's time. We're kind of up on the time limit now. But if you have questions, of course, we're willing to stay and answer the questions. I know a lot of people in the last session got some value out of the questions that everybody asked. So we certainly will continue. You can also put up your hand and we'll do that as well. The next sessions that we're doing, so of course we've got 10 or 11 of these planned anyway, and of course this is our second one out of the 11 series. But really, they're getting generated by your comments, by your questions, by questions that we've had. So things like choosing the right executor, what they need to do properly to settle your estate, and the activities that an executor has to do. Because of course, we've had a lot of people who have tried to solve it on their own, and you know, then you find out 2 years later they still haven't got a clearance certificate from CRA, and they haven't changed mortgage names with mom and dad, and they still have joint accounts with mom and dad. You know, so we obviously want to talk about what are the duties of an executor. For part of that, you know, is if you have suggestions, you can also put that in the questions box. We're going to talk about like probate and legal, what that kind of looks like. We're going to talk about, some people have asked some questions about guardians, so we may go into the more detail on guardians, how you can really screw up your estate and the choices that you make or not make. What else is involved in an estate planning really engagement with us and with Matt, what that really looks like overall, getting into that as well. So those are some types of things. We had someone actually after Tom Dean's ask about, you know, how to do a family meeting. So we've done that with a lot of our clients quite successfully, and it's quite interesting, especially with charities and stuff, and getting the charities to know really what the family wants at the end of the day, and involving the lawyers, because sometimes they can assist in the end too with some of the charity stuff. So really these sessions are going to be generated by you. We're going to do a big Easter special on Tuesday that we're going to give Matt a break here for the one day, and then bring him back the next Thursday. But we're going to do one on Tuesday and just actually involve Jason Bantle, who has All in the Wild galleries in Canmore and Banff. And we've brought him in for a session on our retirement session. I think a few of you have attended. We brought him in, but he's done a really amazing video that we've sent out to everybody. And he's a biologist, which was actually something that I didn't know. And was super interested in this video because he actually brought out some details on COVID and kind of the interaction of animals and what's kind of happened on the etymology of COVID from animals, and sees it from a very different perspective. But he's going to do it kind of from a family presentation, so that really all of your family can be involved for Easter. So we're pretty excited about that with the Easter holidays, and then we'll get back into the estate planning ones with Matt. So If anyone else has any other questions, we're happy to answer them. Or if you want to put your hand up now, of course, we'll just unmute you and you can come on the screen if you have a camera on your computer as well, and we'll put you up. You can press your mic and your camera, or you can just put your hand up and we'll unmute you and you can just ask a question as well. Whatever you want to do there.
Well, it looks like everyone's a little shy, Pam.
Oh, we do have a question, actually. Jessica, okay. If you want to unmute her, I can unmute. Okay, go ahead, Jessica. You're unmuted.
Hang on, just, yeah.
Oh, can you hear us, Jessica? She's got a hand up here. Oh, and the hand went down. Maybe we answered her question. We tried to unmute you. If you can hear us at all, you can go ahead with your question if you have one. If you don't, then nope, I guess she doesn't have a question. Oh, do we have somebody on the line? Can't hear you. You can press your audio too on your screen if it's not working. You can press the green audio on your screen. Nope. Guess we don't have any other questions. Okay, well, we look forward to having everybody here the next session on Thursday, and we'll send you out an invite as well. Thanks very much for everybody's time and for coming.
Thank you.